Levi?
Yes, Your Honor.
Okay. So this is file 24-21875-FH, People versus Eric Brian Levi. We are here today for arraignment on a bench warrant. We are proceeding today partially by video conference, partially in person. Mr. Levi, have you received a copy of your warrant?
No, I have not, Your Honor.
Okay, can you stick your head out and tell the officers there that you need a copy of your warrant?
Absolutely. They said I need a copy of my warrant.
All right, while they're getting that for you, Mr. Levi, I will let you know that the warrant alleges that you failed to appear for a sentencing on October 25th, 2024 at 8:15 a.m. You are entitled to an attorney regarding this matter and any hearings we have regarding this matter. Mr. Daly, who represents you on the underlying case, is present in the courtroom. Mr. Daly, do you want to place your appearance on the record?
James Daly, appearing on behalf of the defendant, Your Honor.
Okay, and I don't know if you had an opportunity to speak to Mr. Levi about this matter.
No, I didn't, Your Honor. But it really doesn't change anything. Mr. Levi has no defense for not showing up. We tried to contact him, did all the things we could to get a hold of him before sentencing. I would recommend that he plead guilty to this violation and he will allow us to expedite the process on the rest of the charges. I don't know if he's willing to do that or not, but he should. Mr. Levi.
Yes, sir.
Are you willing to plead guilty today to the violation for not showing up?
Yes, sir.
Okay. Do you know, Mr. Daly, do we have a pre-sentence investigation report prepared for Mr. Levi yet?
Not that I'm aware of. A PSI originally was prepared on his original charges.
Okay. So we had one ready to go for that last sentence?
Yes.
Okay. All right. So Mr. Levi, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Eric Brian Levi, correct?
Yes.
Mr. Levi, I understand the maximum possible penalty for contempt of court, which is what this would be, is up to 93 days in jail or up to $7,500 in fines.
Yes, Your Honor. I
have to ask you some questions to make sure you know what your rights are before you say anything else, okay?
Okay, I'm sorry, Your Honor.
You understand that you have a right to contest the contempt of court charge and have a trial on it?
Yes, Your Honor.
You understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, Your Honor.
You would have the right to have all the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions, and you also have the right to have me order any witnesses you have for your defense to appear at the trial. Do you understand all of that?
Yes, Your Honor, I understand that.
You're not required to testify at your trial. No one can say anything about you not testifying that against you in any way. On the other hand, you also have the right to testify at the trial if you wanted to testify. Do you understand that?
Yes, Your Honor.
How do you plead to the charge that you violated your bond conditions by failing to appear at sentencing?
Guilty, Your Honor.
You understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've just explained to you?
Yes, Your Honor.
Has anything been promised in order to get you to plead guilty?
No, Your Honor.
Have you been threatened in any way in order to get you to plead guilty?
No, Your Honor.
If I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the record, to the court on the record this morning, or that it was not your own choice to enter the plea. Do you understand that?
Yes, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
So you were, you previously pled guilty in this case to a couple things, and we had set a sentencing date for October 25th at 8:15. Is that correct?
Yes, Your Honor. We
And
did.
you were not present in court for that sentencing hearing. Is that right?
No, I was not, Your Honor.
All right. I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Levi's had full knowledge of his rights to have competent counsel. We still need to do the sentencing on the underlying case. So what I'll do is set sentencing. Are you available Friday, Mr. Daly? If you've already got the PSI, we can. I'll get that taken care of Friday morning.
I'm available Friday. I've got a jury trial starting in Judge Martin's court at 9 o'clock, but I'm available, Judge.
I apologize, Mr. Daly. What did you say?
I'm available on Friday, but I've got a trial starting in Judge Morgan's court at 9 o'clock, but I also have a sentencing with you and Cole Paulding at 8:15, so I can be here.
Okay. All right. So as long, yeah, we can get those taken care of before.
Okay.
Before here enough time.
Thank you, Governor.
All right. So Mr. Levi, we're going to set your sentencing on this and on the underlying case for Friday at 8:15 a.m.
Okay, Your Honor.
All right. So you can let the officers with you know that you're done with court for today.
Okay, am I gonna remain in custody until Friday or?
You have a bond on the bench warrant of $25,000. So if you were able to post that, you could be released, but otherwise you're going to remain in custody.
I think that the 25,000 was, the officer said that it was a misprint. That it was
It's not.
2,700. It's not?
No, the bond on the bench warrant is correct.
Okay.
I think you've got another warrant from district court, so he may have been talking about that one.
Okay. Thank you, Your
All
Honor.
right, so you can let them know you're done with our court for today. Thank you. And then, Mr. Day, are you ready to proceed with Mr. Duff?
Yes, sir.
Okay. Mr. Duff, you want to come forward? Okay, this is file 24-21822-FH People versus James Riley Duff. We are here today for a pretrial conference in this case, and we are proceeding today in person and also by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms.
Before I have the people filling in for prosecutor of record Isaac Sneed.
James Daly on behalf of the defendant.
All right, and Mr. Daly, where do we stand with Mr. Duff's case today?
Your Honor, Mr. Duff has been in counseling with John Daly. He's supposed to complete 27 classes. He's already completed 17 of those classes. He plans on completing the rest of those classes, and he also intends upon pursuant to that resolving this matter.
Okay, so does he need more time then to complete the
Yes,
remaining classes? And
he's got 10 classes left to complete.
And how long will that take?
They're once a week.
Once a week.
Judge, I think in my notes that it reflects that he should be done by mid-December. I think what the date that I had down was December 11th.
Okay, so he's saying He has 10 classes left and there's one a week. That would take us to,
It's really 9 classes, I misspoke there.
so 9 classes, or 9 weeks from today would be January 8th. Although one of those weeks obviously includes Christmas, and another of those weeks includes New Year. So I don't know if that's going to have any impact or not. But why don't we set it for January 8th and see where things stand at that point.
Thank you, Aaron.
And I'm sorry, Ms. McClure, is there anything else we need to address with the case today?
No issue with that, Judge.
Actually, let's make that January 15th. So January 15th at 8:15 a.m. And Mr. Bailey, do you do that stipulation in order for adjournment?
Yes, Your Honor.
Okay. Anything else we need to address today?
No, Your Honor.
Okay, thank you.
Thank you, Judge.
Thanks, John.
Okay.
Okay, so can we have Ms. Rule and Ms. Rule come back forward, please?
Katarina Dumont, procuring rule.
Okay, and so Ms. Demont, how does Ms. Rule wish to proceed today?
Your Honor, we'd like to take responsibility for the violation. The agreement to pay, since it's the first violation of PPO, that it would be a fine.
Right, well, I don't know if that's an agreement you've made with Christine Rule or.
Your Honor, I did contact your office and that's what I was advised of.
I would say that's typically how I handle the matter, but I don't feel at this point I can make that an agreement before the plea is entered, so.
Your Honor, then if we could get another date for a COPS agreement.
I don't know that I have the ability to enter into Cobb's discussions on contempts, and I'm not sure that that's an appropriate course of action. I can give you another date and we can look at that in the meantime, but I don't know that that's. All right, so let's set this out then to November 27th at 8:15 a.m. In the meantime, I will look at that issue, whether it's appropriate for me to engage in Cobb's with the contempt of proceeding.
Thank you.
So November 27th at 8:15 a.m. will be the next date. Thank you. Okay, Mr. Daly, are you ready to proceed with Mr. DeYoung?
Yes, Your Honor.
This is file 24-21968-FH, People versus Michael DeYoung. We are here today for a pre-trial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonetta?
Alex Bayonetta for the people.
James Daly, for in behalf of the attorney.
All right, and Mr. Daly, where do we stand with Mr. DeYoung's case today?
Mr. DeYoung is ready to resolve this matter, I believe.
Okay, and how are we doing that?
He was going to be, he completed the program. Okay.
I went down and did evaluation for the sobriety.
He's done the sobriety court evaluation, that's what he wants to do.
Okay, is there a plea offer, Mr. Bayonetta?
Your Honor, the offer that was extended in district court was to plea to count 1 as charged, count 2 would be dismissed, as well as any habitual second offense notice. There is no agreement as it relates to sentencing. There was discussion of sobriety court. I'm not sure if Mr. DeYoung ever went through with screening for that. I would have no objection to his participation in that program.
He's done the screening.
Okay. All right, is that how he wants to proceed then, by pleading to count 1 with count 2 individual offender being dismissed?
Yes, Your Honor.
Okay, Mr. DeYoung, will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Lee Michael DeYoung?
Yes, Your Honor.
Mr. DeYoung, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, operating while intoxicated, third offense?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is a $500 to $5,000 fine and either 1 to 5 years of probation with 30 days to 1 year in jail, at least 48 hours to be served consecutively, and 60 to 180 days of community service, rehabilitative programs, or, and vehicle immobilization of not less than 1 year or more than 3 years.
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been discussed on the record today. Is that correct, Mr. Bayonetta?
That's correct, Your Honor.
Mr. Daly?
Yes, Your Honor.
Is that also your understanding, Mr. DeYoung?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial, and we can explain those rights to you right now. You do have the right to a speedy public trial by jury. Could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until you're proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, sir, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
You understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead then to the charge that on or about July 28, 2024 in Cambridge Township, Lenawee County, Michigan, that you did commit the offense of operating while intoxicated, the third offense?
Guilty, Your Honor.
Has anybody made any threats or promises to you in order to get you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. DeYoung to plead guilty today?
No, Your Honor.
No, Your Honor.
Mr. DeYoung, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes, Your Honor.
Mr. Daly, do you want to establish a factual basis?
I will, Your Honor. Mr. DeYoung, on July 28th, 2024, were you operating a motor vehicle in Cambridge Township in the county of Illinois?
Yes,
And at the time, had you been consuming alcoholic beverages?
yes.
And your breath test at the time was what?
I don't recall.
Okay. It was over 0.08, is that right?
Yes.
Okay. And you have, and you understand that you were operating while you were intoxicated at the time?
Yes.
I have no other questions to this one, Chair.
Mr. Bayonet, are the people satisfied?
Your Honor, the only thing I would add is, Mr. DeYoung, you would acknowledge that you were previously convicted of operating while intoxicated on February 12th of 2001 in the 2A District Court, as well as of operating while intoxicated on October 30th of 2003 in the 2A District Court?
Believe so, yes.
Okay. I believe that establishes the third offense, Your Honor, and I'm satisfied.
Does the court comply with MCR 6.302 B, C, and D, Mr. Bayonet?
Your Honor.
Mr. Daly?
Yes, Your Honor.
All right, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Young has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation interview and set sentencing for December 19th at 8:15 a.m. Mr. DeYoung, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. Mr. Stevenson, should I have him just step across the hall to probation when he's done?
Yeah, have him come in our office if you would.
Okay, so when you're finished here, just step across the hall to the probation office. They'll collect some information from you and give you a packet of information to take and fill out, return to them, okay?
Yes, Your Honor.
All right, so you're all set for today then, you're free to go.
Thank you, Your
Thank
Honor.
you.
I'll come to you. Yeah. There'll be a few minutes, but I'll be there.
Okay.
Okay, Mr. Amadeo, are you there?
Yeah, Your Honor, I apologize. I'm in Shiawassee, but I went out to my car. I apologize for not being able to hear earlier.
Okay, no problem. You're here for Carly Frank.
That's correct, Judge, and I don't know if she's there or not. They just asked me to take over this file.
Yeah.
Is she in Zoom?
Is present in person here in the courtroom, I believe, and but also her case we got a nollie pros earlier this week or late last week, and that case has been dismissed.
Okay. So she has no active cases with you, Judge?
Judge, if who can this is my case and I did not file an Ollie Pros. I'm sorry.
Oh, I'm sorry. I think maybe I have this. Maybe I have the wrong file that I'm thinking about. I apologize for that confusion. I was thinking about a different file.
Okay, no problem. I just want to make sure we didn't get ahead of ourselves.
Okay, so let's back up then. Mr. Amadeo, Ms. Frank is here in the courtroom. Are you going to need to speak with her?
Your Honor, if I could ask for a 30-day adjournment for the pretrial to get familiar with the file, and if I could speak, prepare a stip, Judge, and if I could speak to her privately, not to hold you up, just to get her contact information, because I've not been able to get her number. I do want to meet with her, but I don't want to hold you up either.
Okay. Ms. McClure, do you have any issue with that?
No, Judge, I know Mr. Amadeo just took this case over from Ms. Hennigan. I think he's had some trouble getting all of the full file. So I'm happy to get him whatever discovery he needs in this brief adjournment, and hopefully we can discuss the case in the meantime. I also, like I said, know he needs to get her contact information, so however the court can assist with that.
Okay, so how about December 11th at 8:15?
That's great. Thank you, Judge.
That works.
And I'll get a if that works, Your Honor.
Okay. So Ms. Frank, if you'll step outside to the hallway, there is an iPad out there. I will put you in a breakout room with Mr. Amadeo so that you can speak to him privately.
Thank you, Aaron.
Thank you, Judge.
And Mr. Amadeo, you can come by anytime and go through my file. It's pretty voluminous, so I just want to make sure you get everything.
I appreciate it. I'll connect with you and I'll work around your schedule and I'll get out there and grab everything. I'll make copies, whatever I need, if that's cool.
Yep.
Thanks.
Okay, so Ms. Frank, I'm going to send you a request to unmute. If you tap the screen, you should see a microphone with a red slash through it, and if you tap that, you'll unmute the device. All right, if you hang on a second, we'll have someone step out to the hallway and help you with that.
Thank you, Judge.
Can you help her with the iPad? She can't get it unmuted.
You're okay, Judge, can you hear us?
Okay, yeah, we're all set now, so give me just a second and we'll set up that breakout.
Thank you.
Go for the time.
Could we have Tyler Hassler and the judge, please? Thank you. Bye.
Yes, Jessica.
Okay, Mr. Burkett, are you there? Mr. Burkett, can you hear me? Okay, Mr. Dill, we do have your attorney logged in. As soon as he's back in front of his device, we can call your case.
I apologize, Aaron. I was having a problem with my computer. I finally got it to work.
All right, there he is. So Mr. Burkett, are you ready to proceed or do you need to speak to Mr. Dill?
I am ready to proceed, Your Honor, and thank you for your patience.
Okay. So this is file 24-21967-FH, People versus Deontay Laquan Hill. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people, filling in for prosecutor of record Isaac Sneed.
Your Honor, I'm sorry. Good morning to you and your staff. Raymond Burkett appearing on behalf of Mr. Dill.
Okay, and Mr. Burkett, where do we stand with Mr. Dill's case today?
Well, Your Honor, what I'm going to ask this honorable court to do is to just keep this case on track. I have already ordered the preliminary exam transcript. At this juncture, I anticipate filing a motion to quash.
Okay, so you ordered that transcript but don't have it yet, is that correct?
Yeah, I ordered a couple, many weeks ago.
Okay.
Looks like the exam was on September 16th. So
Okay.
what do we need, 60 days from there? Which is pretty close to now.
All right, so let's set this out then for about days. Let's set it for another pretrial on December 11th at 8:15 if that date works.
Can you be kind enough just to give me one brief second?
I'm sorry, well, I did catch the tail end of what you said.
No, I'm gonna ask you this honorable court, could you just give me one brief second? Did you say December the 11th?
Yes.
Your Honor, let me ask you this one other question. Because I'm recovering from a real bad accident, can that too be done by Zoom?
Yes, that can be by Zoom.
Okay, and what time, Your Honor?
That would be 8:15 a.m.
I appreciate your patience and kindness. Thank you very much.
Okay. So Mr. Dill, your next date will be December 11th at 8:15. You can use all the same Zoom information that you used today to log back in.
Okay, thank you.
Right. All right. Thank you. You're all set. Then you can go ahead and log out.
And Judge, I'll do the stip in order to adjourn that. Mr. Burkett, can we sign your name to that with your permission?
I would be honored if you would.
Okay, no problem.
Okay. Thank you very much, Ms. McClure. Okay, Mr. Glazier, we have Mr. Neimer here in the courtroom.
Oh, okay, yes, I was wondering if he was there.
Do you need to speak to him or are you ready to proceed?
I think I'm ready to proceed, Your Honor.
Okay, Mr. Neimer, you want to come forward to the podium, please? Okay, these are files 24-21792-FH, 24-21872-FH, and 24-21873-FH. People versus Bailey Assad Neimer. We're here today for pretrial conferences in each of those cases. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
B.B. McClure on behalf of the people.
John Glazier on behalf of Mr. Neimer.
All right, and Mr. Glazier, where do we stand with Mr. Neimer's cases today?
Your Honor, I would ask to adjourn this either a week or 2 weeks at the longest. And I need to speak with Mr. Neimer in my office. And hopefully we'll get this resolved at probably by a plea at the next hearing.
All right, Ms. McClure, anything to address from the people's standpoint?
Just to make a record that it looks like there was an offer that's been outstanding since June. And I know the court indicated last time that they would not grant any other adjournments on the oldest case. So we have no objection to an adjournment if there's a possibility of a resolution. I just wanted to make a record of that.
Okay. So if it's a couple weeks, I can live with that, but yeah, these cases are all getting old at this point. And so if there's no resolution at the next pre-trial, I am going to set the oldest case for trial at that time. So We can do November 27th at 8:15 a.m.
Did you say 8:15?
Correct.
Mr. Nimer, come in and see me before that date, and on that date, we'll do it by Zoom from my office.
Got it.
On the 27th, you don't need to be, we'll do it by Zoom from our office. But I just want to make sure we got everything squared out, so come in and see me before that date as well. Set an appointment.
Got it.
Okay, that's all, Your Honor.
Okay, so thank you, Mr. Nyman. You are all set for today. Mr. Glazer, would you do the stip in order for adjournment on that case, for those
Yes, I
cases?
will, Your Honor.
Okay, Mr. Dagger Margosian, are you ready to proceed with Mr. Hostler?
Your Honor, if I may speak with him briefly.
Yeah, 1 second. Okay, and for Richard, if they have another good morning, Mr. Sherwood. We're just waiting for your attorney, Mr. Mawad, to get logged in. He's probably doing cases in.
Judge,
Oh.
I'm here. My apologies, I'm here.
Okay. I apologize, Mr. Mawad. I forgot that I've got too many names in here and I lost track of you.
No, Judge, absolutely no problem. No problem at all.
Okay. Do you need to speak to Mr. Sherwood or are you ready to go?
We're ready to go, Judge.
All right. So this file 24-21855-FH, People versus Charles Thomas Sherwood. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Ms. McClure.
Phoebe McClure on behalf of the people.
Your Honor, good morning. Elias Muwad appearing on behalf of Mr. Sherwood.
Okay, Mr. Yep, and we have Mr. Sherwood here by video conference as well. Mr. Mawad, where do we stand with Mr. Sherwood's case today?
Judge, Ms. McClure and I talked yesterday. She did make an offer. I submitted that offer to Mr. Sherwood. I'd like to request one more adjournment, and I want to talk to him a little bit more about that. So it's a, if I'm okay, Phoebe, to tell him it's a child abuse 3rd degree, and I want to talk to Mr. Sherwood a little bit more about that, and Ms. McClure a little bit more about that. So just one more adjournment, Judge.
And Judge, it is a new offer that I made based on new information from Mr. Mawad. It's a lesser offer than what I had made previously. So if they need time to consider that, I'm all for that.
Yeah, that is correct. What Ms. McClure said, that's 100% correct.
All right, how about November 27th?
Yeah, that should work, Judge. Sure.
Okay, so let's go with November 27th at 8:15. Mr. Mawad, would you prepare a stipulation in order for that adjournment?
Yes, and Ms. McClure, can I sign your name to it, please?
Yes, you can.
Okay, I'll be in touch. Thank you, everybody. Thank you.
Only other issue we need to address is fingerprints. I did enter an order for fingerprints back on October 16th. And still don't see fingerprint information in the file, so we need to make sure that gets done.
Mr. Sherwood, I think we discussed that way back then. Did you get your fingerprints taken and go to
Yes, I went to Michigan State Police Post Monroe, which is I called the one in Adrian, which you told me I had to go to the police department that arrested me, which was Monroe State Police Post. I went there and had my fingerprints on October 7th.
Did you get a piece of paper? Did you get a piece of paper back from them or to file with the court or anything, or no?
I gave them the copy of the order for the fingerprints.
Okay.
And he handed it back to me with no signatures or anything on it. I was under the assumption that it was in their system and that they would deal with it from there.
Okay. Okay.
We'll see if we can try to track it down from our side.
All right. I appreciate the court. Thank you very much.
Okay, you're all set then, Mr. Sherwood. You can go ahead and log out.
Thank you.
Thank you.
Okay, Mr. Dagger Margosian, are you ready to proceed with Mr. Hostler?
Yes, Your Honor.
This is file 24-22024-FC, People versus Tyler Anthony Wayne Hostler. We're here today for a pretrial conference. In this case, we are proceeding today by video conference. First, I have the attorneys place their appearances on the record, beginning with Mr. McCready.
Good morning, Your Honor. Dave McCready for the people.
Your Honor, Michael Dagger Margosian for Mr. Hostler.
All right, and I do have a signed plea agreement and amended information in the file. Are we ready to have a plea entered at this time?
Yes, Your Honor.
Okay, do you, in addition to having the written plea agreement, do you want to place that on the record then, Mr. Dagger?
Yes, Your Honor. Your Honor, the plea agreement is that Mr. Hostler will be pleading guilty to assault with intent to commit great bodily harm, and in exchange for that, the original information will be dismissed. There's also a sentencing agreement that Mr. Hostler will be placed on probation for 3 years. The first year being in Lenawee County Jail, obviously minus the time that he's served so far. Additionally, there will be a no contact with Kiana Williams. There will be anger management as part of probation. There will be substance abuse counseling as part of probation, and Mr. Hostler will be placed on HIDA if eligible, which he is by the offense that he's pleading to, as well as his age.
All right, Mr. McCready, is that a complete and accurate statement of the agreement?
Yes, it is.
Mr. Hostler, will you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
I do.
And you are Tyler Anthony Wayne Hostler?
Yes, Your Honor.
Mr. Hostler, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 4 on the amended information, assault with intent to do great bodily harm, less than murder, or by strangulation?
Yes, Your Honor.
Are you satisfied with Mr. Dagger Margosian and the advice that he's given?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison or $5,000 fine?
Yes, Your Honor.
Neither the prosecutor, defendant, nor anyone acting on the defendant's behalf has discussed a possible sentence with court other than as we've discussed it on the record here today. Is that correct, Mr. McCready?
Correct.
Mr. Dagger Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Hostler?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. you understand, Mr. Hostler, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
Do you understand that you're giving them up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about June 30, 2024, in the city of Adrian, county of Lenawee, that you did commit the offense of assault with intent to do great bodily harm less than murder?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Hostler to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Hostler, has your attorney promised you any particular sentence or estimated what your sentence would be other than, as we've discussed it on the record this morning?
No, Your Honor.
Is it your own choice to enter the plea?
Yes, Your Honor.
Mr. Dagger Margosi, do you want to establish the factual basis?
Mr. Hostler, on June 30th of this year, were you in the city of Adrian, county of Lenawee, state of Michigan?
Yes, Your Honor. I'm there. I'm there.
It's okay. All right. And on that date, did you fire a pistol?
Yes.
And was that in the direction of somebody?
Yes.
And would you agree that that act is an assault?
Yes.
And your intent at that time was to cause great bodily harm to an individual?
Yes.
Okay. I think I'm satisfied with that, Your Honor.
That individual is Kiana Williams.
Yes, Your Honor.
I'm satisfied.
All right. Has the court complied with MCR 6.302 B, C, and D, Mr. McCready?
Yes.
Mr. Dagger Margosi?
Yes, Your Honor.
All right. I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Hostler has had full knowledge of his rights to have competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department and set this for a pre-sentence investigation and set this for sentencing on January 9th at 8:15. Mr. Hostler, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about the offense and about your background.
Okay, Your Honor.
All right, anything else we need to address today, Mr. McCready or Mr. Dagger Margosi?
No.
No, Your Honor. Thank you.
Okay, Mr. Hostler, you can let the officer with you know that you're done with court for today.
Okay, thank you, Your Honor.
I have a device logged in as SLF Hearings 1. Is there anyone there that can hear me?
This is Joseph Colwell from the prison. And Joseph Michael Colwell. That's not yours. Thank you. Bye.
To have someone logged in as Motorola Moto G Play 2024. Can you unmute your device and tell me who you are?
Yes, my name is Steve Johnson.
Okay, 1 second, sir. All right, Mr. Johnson, your attorney is not logged into this court right now. She is handling cases in another court. I'm going to put you back in the waiting room. As soon as she gets logged in here, I'll bring you in and we'll start your hearing.
Okay, Your Honor.
And the gentleman at the jail, are you Mr. Rutledge?
Yes, sir. Yes, sir, I am.
Mr. Glazer, do you need to speak to Mr. Rutledge?
Yes, Your Honor.
Okay, I'll put you in a breakout session right now. Give me just a second. A device logged in as SLF Hearings 1. Is there anyone there that can hear me? Okay, this is file 24-22028-FH, People versus Richard Roy Rutledge Jr. We are here today for a pretrial conference. I'm sorry, we're here today for an arraignment in this case. And we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
B.B. McClure, on behalf of the people.
John Glazier on behalf of the defendant, Your Honor.
And Mr. Glazer, does Mr. Rutledge wish to have the information read today?
Now, we'd waive the reading of the information, Your Honor. And before we proceed any further, could I speak with Miss McClure for a minute? I tried calling her and she must have been busy.
I can just call you real quick, John.
All right. Let me mute.
Okay.
Judge, I think we're gonna proceed with a plea on this case. It looks like you may need an amended information, and I'm doing a very quick plea form as well.
Okay. They have a second.
Judge, if he's pleading from instead of a DV third to a DV second, do you need an added count of that, or would I just amend the DV third to be a DV second?
I think you can just change that as opposed to adding a new count.
Okay.
Okay, let's see. Okay, Ms. Underwood, we have Stephen Johnson here. Do you need to speak to him?
Yes, just briefly, Your Honor.
Okay, Mr. Johnson, I'm going to put you in a breakout session with Ms. Underwood.
Okay.
Okay, this is file 24-21757-FH. People versus Stephen Jermaine Johnson. We're here today for a pretrial conference. In this case, we are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Brent.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the people.
Good morning, Your Honor. Rhonda Underwood for Mr. Johnson this morning.
All right, and Mr. Johnson is also present by Zoom. Ms. Underwood, where do we stand with Mr. Johnson's case?
Mr. Johnson has found gainful employment, regular employment at KFC, Your Honor. He is getting a larger check today, and he should be able to make a payment. He also has given that information to the friend of the court, so income withholding should be forthcoming. I am asking for the patience of the Attorney General and the court and setting this over one more time, just a couple weeks, Your Honor. And maybe by then those things will be in and we can get a resolution to this matter on that date.
Your Honor, I think we should do a plea today and set out sentencing 60 days. And if he's paying between now and then, I would agree to no upfront jail. But I mean, he's made very little efforts since he posted his bond in March of 24. There was a $150 payment last month, and his arrearages have now climbed to almost $11,000. So I think we should resolve it at this point. I don't know if Rhonda wants to talk to her client some more. I had advised at the last hearing that I was not going to agree to additional adjournments without payment efforts, and there have not been any.
Okay, so Ms. Underwood, do you want to talk to Mr. Johnson further, or?
For a minute, Your Honor.
Okay.
I just forwarded everything for Mr. Rutledge's plea.
Okay, thank you. Okay, we can go back to Mr. Rutledge's case. So we're back on record there. I do have the amended information and a copy of a plea agreement. All right, so Mr. Glazer, do you want to state your understanding of the plea agreement? You are muted, Mr. Glazer.
There we go. My client's going to plead guilty to possession of methamphetamine and without a supplement, the sup would be dismissed, and he's going to plead to domestic violence second, which is a 1-year misdemeanor. There is a Killebrew agreement that there would be no prison, that the maximum he would face would be up to a year in jail.
And oh, sorry, Judge. Just to clarify a couple things, just to make sure it's not illusory, I did not add the drug supplement on his information and when he was charged. So it wouldn't be to dismiss that supplement, but it would be to not add that supplement upon entry of the plea. But he did have a prior possession of meth that could have made this a double penalty possession of meth. And then as Mr. Glazier indicated, that domestic violence would be a second offense rather than a third offense. Count 3, 4, and the habitual will be dismissed. And I did indicate on the plea form that while he's currently on parole, the parole officer did indicate, separate from this agreement, that they would not be sending him back to Michigan Department of Corrections for this violation. But it is worth noting that because he's on parole, the court has the discretion to impose a consecutive sentence if necessary, but we are agreeing at this time for no upfront Michigan Department of Corrections on this file.
And is that all accurate, Mr. Glazier?
Yes, it is, Your Honor.
Okay, Mr. Rutledge, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Richard Roy Rutledge Jr.
Yes, I am.
Mr. Rutledge, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, possession of methamphetamine or ecstasy?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 10 years in prison and or a $15,000 fine?
Yes.
Is it also your intention to plead guilty today to domestic violence second offense?
Yes.
Do you understand that the maximum possible penalty for that offense is up to 1 year in jail and or a $1,000 fine?
Yes.
Are you satisfied with Mr. Glazier and the advice he's given you?
Yes, I am.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as it's been discussed on the record today. Is that correct, Ms. McClure?
That's correct.
Mr. Glazier?
That's correct, Your Honor.
Is that also your understanding, Mr. Rutledge?
As far as the sentence?
Yeah, so the question is, do you agree that no one has discussed a possible sentence with me other than as we've discussed it on the record today?
Oh, yes, yes.
Okay. If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you right now. You have the right to a speedy public trial by jury. You can't ask for a non-jury trial. And if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand you're giving those rights up?
Yes, I do.
How do you wish to plead to the charge that on or about October 10, 2024 in the city of Adrian, county of Lenawee, that you did commit the offense of possession of methamphetamine?
Guilty.
And how do you wish to plead to the charge that on or about October 10, 2024 in the city of Adrian, county of Lenawee, you did commit the offense of domestic violence second offense?
Guilty.
Has anybody made any threats or promises to you to get you to plead guilty to those charges?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that the pleas were given as a result of threats or promises not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea.
I understand, Your Honor.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than plea bargaining to induce Mr. Rutledge to plead guilty today?
No, Your Honor.
None, Your Honor.
Mr. Rutledge, other than as we've discussed it on the record today, has your attorney promised you any particular sentence or estimated what it would be?
No, Your Honor.
Is it your own choice to plead guilty today?
Yes.
Mr. Glazer, do you want to cover the factual basis?
I do. Just a couple preliminary. Mr. Johnson, there's been talk about the parole not sending you back to prison, and you've heard that mentioned here today. Is that correct?
Yes.
You understand that is not part of this plea agreement. The officer can still send you back. That's up to her.
Yeah, I understand that.
Okay, that's not a part of this plea bargain. I wanted you to understand that.
Yeah.
That's just based on what the parole officer has told you up to this point. Is that correct?
Right, right.
And you understand that could change and she might ship you.
Yes.
if she
I
decided to.
understand. I understand it's up to the PV specialist. I do understand that.
All right. In regards to this particular offense, is it true you were here in Lenawee County on or about October 2nd of 2024?
What's
It's
that?
going to be October 10th.
So is it true that you were here in Lenawee County on or about October 10th of 2024?
Yes.
And on that date, did you assault a Yvonne Fielder?
Fiedler.
Fiedler? Yeah.
Yep.
Sorry.
Yes. Yes.
What'd you do? Hit her, punch her? What did you do?
Oh, I had butted her.
Head butted her? Okay. And she is a person you had a dating relationship with?
Yes.
All right. And this, you have a prior domestic violence, is that correct?
Yes.
At least one on, let me see if I can get the date here.
2007.
2007, you had a prior?
Yes.
Actually, you have a couple priors, is that right?
No, there should only be one.
Just one?
The other ones were disorderlies.
Okay. Is it also true in that when they arrested you, they found some methamphetamine?
Yes, they did. It was very little, but yes, they did.
Okay, and that was in your possession?
Yeah, it was in my pants pocket.
Okay. I don't have any other questions.
I'm satisfied with the factual basis.
Okay, has the court complied with MCR 6.302 B, C, and D?
Yes,
It
sir.
has.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Rutledge has had full knowledge of his rights. He's had competent counsel. Court's not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 9th at 8:15 a.m. Mr. Rutledge, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about these offenses and about your background.
Right.
Okay, you are all set, then you can let the officer with you know that you're done with court for today.
Judge, what was that sentence date?
January 9th.
Okay, thank you.
Thank you, Your Honor. That's all I have with you this morning.
Okay, thank you, Mr. Glazer. All right, so we can go back to Mr. Johnson. Just make sure we have. All right, so back on the record in People versus Stephen Jermaine Johnson. Ms. Underwood, you've had an additional opportunity to speak to Mr. Johnson. Do you know how he wants to proceed today?
Yes, Your Honor. Mr. Johnson is going to enter a plea this morning. If the Attorney General would put that on the record.
So, Your Honor, he would be pleading guilty to count 1. We would ask that you set out sentencing 60 days. If he pays his child support as ordered between now and the time of sentencing, we would have a sentencing agreement to no upfront jail.
All right, Ms. Was that a complete and accurate statement of the agreement?
That is an accurate statement, Your Honor.
Mr. Johnson, will you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Stephen Jermaine Johnson, is that correct?
Yes.
Mr. Johnson, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, failing to pay child support?
Yes.
And I'm not sure, it kind of looks like you might still have your hand up. You can put it down if you want to. Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $2,000 fine?
Yes.
Are you satisfied with Ms. Underwood and the advice she's given?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record today. Is that correct, Ms. Brenner?
That's correct, Your Honor.
Ms. Underwood?
That's correct, Your Honor.
Is that also your understanding, Mr. Johnson?
Yes.
If a plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You have the right to a speedy public trial by jury. You can't ask for a non-jury trial. If the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You also have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial, not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Johnson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime could result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
Do you understand that you're giving them up?
Yes.
How do you wish to plead to the charge that on or about July 1, 2022 through July 31, 2023 in the city of Adrian, County of Lenawee, that you did commit the offense of failing to pay child support?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Johnson to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Johnson, other than as we discussed on the record today, has your attorney promised you any particular sentence or estimated what it would be?
No.
Is it your own choice to plead guilty today?
Yes.
Ms. Underwood, do you want to cover the factual basis?
Thank you, Your Honor. Mr. Johnson, in the County of Lenawee, in the city of Adrian, County of Lenawee, state of Michigan, you had a child support obligation in the Lenawee County Circuit Court, file number 20190-46971 DP. Correct?
Yes.
And that was to a complainant, Kaylee Huber.
Yes.
And you failed to pay that. And between the dates of July 1st, 2022 and July 31st, 2023, you failed to pay that child support obligation as ordered, correct?
Yes.
And you knew that you had that child support obligation.
Yes.
I believe the facts are sufficient, Your Honor.
People are satisfied as well, Your Honor.
Okay. Has the court complied with MCR 6.302 B, C, and D, Ms. Brenner?
Yes, Your Honor.
Ms. Underwood?
It has, Your Honor.
All right, I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Johnson has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. We'll refer this matter to the probation department and set sentencing for January 10th.
I'm sorry.
January 10th at 8:15 a.m.
Thank you, Your Honor.
Mr. Johnson, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, Your Honor.
And
Can we get his contact?
Yeah, I'm going to put you in a breakout session with Mr. Stevenson so that he can get your contact information. Okay, Mr. Johnson?
Yes.
Okay. Okay, so Mr. Johnson, the only other thing is that the court entered an order for fingerprints back on October 16th, and we still don't have that fingerprint information. Have to have that before the sentencing hearing.
Yes, yes,
Okay.
Your Honor.
So you need to go to the Michigan State Police Post and make sure that your fingerprints are done.
Yes, I talked to, yes, I've been directed, yes.
Okay.
But
All right, so January 10th at 8:15 is your next date.
Okay, thank you, Your Honor.
You can log out, thank you. Okay, Ms. Underwood, Mr. Hall is here in person. Do you want to take care of him next?
Well, do we have Mr. Colwell on the Zoom, Your Honor?
No, I have a device that I think is probably his facility, but the screen is blank and I have not been able to get anyone to respond.
Okay. Yes, I can go talk to Mr. Hall. Thank you.
Okay. We can do the Derek Key. This is file 23-21419-FH, People versus Derek Eugene King. We are here today for a hearing on a summons for probation violation. The record should reflect that this matter was set for a probation violation hearing this morning at 8:15 a.m. Mr. King was ordered to appear here at that time. It is now 9:45 a.m. Mr. King has not appeared here today, either in person or by video conference. So we're going to find he's failed to appear and issue a bench warrant for his arrest. I will set bond on that bench warrant in the amount of $50,000.
Thank you, Judge.
Thank you, Ms. Holly. Mr. Dagamagosian, I don't have Mr. Skinner here. Have you had any contact with him?
Your Honor, I haven't. There was some indication in district court if he was going to be, and Mr. Coast just logged on, maybe he has more information, but there's some indication that he would be going to a veterans facility in Battle Creek. I haven't had contact with him, so that's all I can provide to the court.
Okay, Mr. Coast, do you have any information about Mr. Skinner?
Judge, he was ordered to do 3 times a week drug screening as part of his bond conditions. I have 3 addresses for him. The current address doesn't exist. The street address, there is no street in Adrian that he's listed. Also, I have a street address of 366 Crystal Springs. I did go to that residence. The homeowner there advised that he does not live there. I also have a street address on 540 James, went there. He does not live there. I've not been able to reach him, and he's not been drug testing. At this time, I don't know his whereabouts.
All right, well, I guess I haven't called the case yet. So the file's 24-22029-FH, 24-22030-FH, and 24-22031-FH, People versus Patrick Lee Skinner. These were set for arraignment today. Mr. Skinner is not present, either in person or by Zoom. Mr. Dagamagosian, do you know if you have any way of finding out whether he's at that VA facility?
I can try to follow up, but candidly, I did advise Mr. Skinner when he gets there, when he presumably would have gotten there to reach out to me. That has not happened. I can try to follow up and try to locate him, but it's been unsuccessful up until now.
All right, so what I'm going to do is, as far as I know, his first failure to appear. I'm going to give him a 48-hour grace period. If we haven't figured out where he is between now and then, I will issue bench warrants in each of the files for his arrest and set bond on those bench warrants in the amount of $10,000 each. If you are able to locate him at that facility, obviously Mr. Gagnon goes and let us know, and we will either not issue or call those warrants. I have our Veterans Court this afternoon, so I don't know if I'm able to gain any information through our VA contact there. I don't know what he might be able to share with me, but I'll make an inquiry there, and if he's able to share any information, I'll let you know anything that I find out.
Thank you.
All right, I think we're all set with that case then. Juwan Williams. I call the children with bloods. Okay, Mr. Murphy, we have Ms. Kately here in the courtroom. Do you need to speak to her?
Yeah, if I could briefly, Your Honor, I could call her if she has her phone, or she could call the office, or I could just talk to her over Zoom.
All right, Ms. Kately, do you have a phone on you? Do you have his number? Okay, Mr. Murphy, do you have Ms. Kately's number?
I believe so, yes, Your Honor.
Otherwise, we've got the iPad running. She can just step out into the hallway and do it that way.
Yeah, I'll give her a call. Her phone number ends in 6023, correct?
Yeah.
Okay, yeah, I'll give her a call.
If you want to step out to the hall, he'll call you right now.
Okay, thank you.
Okay, Ms. Kaylee, if you want to come forward to the podium, I think we're ready to call your case. Okay, this is file 24-21883-FH. People versus Taylor Lee Gately. We are here today for a pretrial conference. In this case, we're proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Hartung?
Thank you, Your Honor. Good morning, Doug Hartung, appearing today for the people.
Matthew Murphy, appearing on behalf of Mrs. Gately.
And Ms. Murphy, where do we stand with Ms. Gately's case today?
Your Honor, I'm asking if we could adjourn this just for one more pretrial. I need to have some more discussions with Mr. Hartung. Ms. Gately was in Harbor Light. She completely successfully completed that. I wanted to make sure with that, see how she's doing with her sobriety. So again, if Mr. Hartung doesn't object, I'll just ask for an adjournment.
No objection.
Okay, we could do December 11th at 8:15 if that date works for everyone.
Is that okay with you, Mr. Hartung?
That looks good.
Can we do that, please, Your Honor?
So December 11th at 8:15 a.m. Mr. Murphy, would you do that stipulation in order?
I will, Your Honor. Thank you.
You can sign my name, Matt.
Okay, thank you.
I have to go downstairs to Morgan. I believe Matt Murphy needs to know too.
Okay. Mr. Murphy, she has something with Judge Morgan this morning also.
I don't know.
I got the paperwork right here.
Yeah, I don't have it on my docket. It might be something that's we're not appointed to.
Okay.
I see something for next week on the 12th.
No, this one says the 6th at 8:45 a.m.
Yeah, I don't have anything for you down in district court, so you probably want to go down there because it's probably not appointed to whatever that is.
Okay.
Okay. So your next date here will be December 11th at 8:15.
Okay.
All right, so you're all set.
Thank you.
Thank you.
Thank you, Your Honor.
And Mr. Murphy, do you need to speak to Mr. Blevins?
Briefly, Your Honor.
Sir, are you Mr. Colwell?
Yes.
Okay, your attorney is working with another client right now. As soon as she's done with him, I'll have her speak to you.
I'm a Miss Chow. I'm Miss Medication. I'm a Miss Medication. I'm Miss Chow. I'm Miss going to school.
All right, it's going to be about 5 minutes. So I'm going to put you back in the waiting room for a couple minutes.
All right.
You want to bring Mr. Hall? Yes. Okay, this is file 24-21859-FH People versus Heath Michael Hall. We are here today for a pretrial conference in the case. We are proceeding today by, in person. First, can I have the attorneys place their appearance on the record? Do we have somebody from the prosecutor's office?
Sorry, Judge. Phoebe McClure, of the people.
Rhonda will do it on behalf of Mr. Hall this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Hall's case today?
After meeting with Mr. Hall this morning, Your Honor, I have serious concerns as to Mr. Hall's competency and criminal responsibility in this matter, Your Honor. And I would ask the court to allow me to present orders for a forensic examination in this matter and for the case to continue in that way.
Okay, Ms. McClure, anything you want to say with respect to that issue?
No, nothing on behalf of the people.
All right, at this time, then I will order evaluations for competency and for criminal responsibility. Ms. Underwood, if you want to prepare and submit those, I will sign them and receive.
Thank you, Your Honor.
All right, thank you.
That's it.
That's it for today. Thank you. And then, Ms. Underwood, Mr. Colwell is logged back in, so if you want to get on your device.
I'll go on back.
Okay, so Mr. Murphy, are you ready to proceed with Mr. Blevins?
Yes, Your Honor.
This is file 24-21929-FH People versus Nicholas Montgomery Blevins. We're here today for a final pretrial conference in this case. We are proceeding today by video conference. First, I have the attorneys place their appearance on the record, beginning with Mr. Gumto.
Good morning, Your Honor. Dan Gumto for the people.
Matthew Murphy, appearing on behalf of Mr. Blevins.
And where do we stand with Mr. Blevins' case today, Mr. Murphy?
Your Honor, I apologize. I don't have a written plea agreement from the people, but from my understanding, the people are willing to offer for Mr. Blevins to plead to 2 counts of resisting and obstructing an officer, dismissing the remaining 2 counts on the information, dismissing habitual offender notice, and that there'll be an agreement for no more jail at sentencing in this matter. If that, and again, if that's my understanding of the plea offer, is that correct, Mr. Gumtow?
Yes, that's correct.
Mr. Blevins does wish to accept the offer and plead guilty to, again, those 2 counts of resisting and opposing officers.
All right, Mr. Blevins, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
You are Nicholas Montgomery Blevins?
Yes.
Okay, and Mr. Blevins, have you heard the statement of your attorney and the prosecuting attorney? Is it your intention to plead guilty today to count 1, assaulting, resisting, obstructing a police officer?
Yes.
You understand the maximum possible penalty for that offense is up to 2 years in prison and or a $2,000 fine?
Yes.
Is it also your intention to plead guilty today to count 2, second count assaulting, resisting, obstructing a police officer?
Yes.
And you understand the maximum penalty again for that offense up to 2 years in prison and or a $2,000 fine?
Yes.
You satisfied with Mr. Murphy and the advice that he's giving?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it on the record here today. Is that correct, Mr. Gumtow?
That's correct, Your Honor.
Mr. Murphy?
Yes, Your Honor, that's correct.
Is that also your understanding, Mr. Blevins?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them.
Yes.
You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent at your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Blevins, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No.
And do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about August 16, 2024, in the city of Adrian, county of Lenawee, that you did commit the offense of count 1, assaulting, resisting, obstructing a police officer?
Guilty.
And how do you wish to plead on to the charge that on October 16, 2024, in the city of Adrian, county of Lenawee, that you did commit the offense of count 2, second count of assaulting, resisting, obstructing a police officer?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to those charges?
No.
Do you understand that if I accept your pleas, you're giving up any and all claims that your pleas were given as a result of threats or promises disclosed to the court on the record this morning, or that it was not your own choice to enter the pleas?
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Blevins to plead guilty?
No.
Your Honor, I told Mr. Blevins I would ask the court to address bond after the plea is entered. Other than that, nothing else.
Okay. Mr. Gumtow, you aware of any promises, threats, or inducements other than the plea bargain?
No, Your Honor. Thank you.
Okay. Mr. Blevins, has your attorney promised you any particular sentence or estimated what it would be?
Just what he told me.
Okay, other than as we've discussed.
No,
on the
no,
record-
no.
Sorry, is it your own choice to plead guilty today?
Yes.
All right, Mr. Murphy, do you want to cover the factual basis?
Yes, Your Honor, thank you. Mr. Blevins, can you hear me okay?
Yes, sir.
Okay, Mr. Blevins, were you indeed in the city of Adrian, County of Lenawee, State of Michigan on August 16th of 2024?
Yes.
Okay, and on that date and time, did you come in interaction with two police officers of the Adrian City Police Department?
Yes.
Okay, and you were aware that they were police officers, correct?
Yes.
Okay, and did they try to, did they identify you and try to take you into custody on some outstanding warrants?
Yes.
And did you resist them taking you into custody on those warrants?
Yes.
Your Honor, I have no further questions. I'm satisfied with the factual basis.
Mr. Gumto, are the people satisfied?
Yes, we are. Thank you, Judge.
Mr. Blevins, can you just tell me briefly what you did to resist or oppose the officers?
I just gave him a fake name, and I wouldn't let him arrest me. I wasn't fighting them, but I wasn't letting them arrest me.
When they were trying to place handcuffs on you, you were pulling your arms away and trying to resist that action of placing the handcuffs on?
Yes.
Okay. Has the court complied with MCR 6.302 B, C, and D, Mr. Gumto?
Yes, Your Honor.
Mr. Murphy?
Yes, Your Honor, thank you.
I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Blevins has had full knowledge of his rights. He's had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of Indian. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for January 9th at 8:15 a.m. Mr. Blevins, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
Your Honor, may I briefly address bond?
Go ahead.
No, Your Honor, in this incident, again, Mr. Blevins, as he indicated, the officers identified him. They knew that he had outstanding warrants. He tried to say that he was his twin brother, and that he did pull away. He did not want to be taken into custody at that time. We're not denying or trying to downplay the actions at the incident. He does obviously want to accept responsibility and move forward with sentencing on this. Now, he has been in custody since the incident. He is serving a sentence that should be up next week, I believe November 11th, for a violation of probation that he is still on that probation for. We're asking the court to consider a PR bond. Again, he won't be released today. It will be next week if he was released, and then he's not going to be completely out. Obviously, he has bond conditions the court has imposed and will impose moving forward. Plus, he has his probation he has to report and be concerned about as well. Again, Mr. Blevins is not trying to downplay his actions. He does apologize for them, but we are asking the court to consider a PR bond. We don't believe it's a necessity to keep him in custody between the date, this date and sentencing date. But obviously, whatever the court orders, he will abide by the orders of the court. So we'd ask the court to consider, though, a PR bond.
The people take no position with regard to bond, Your Honor.
Okay, I'll reduce the bond to a personal recognizance bond. with the conditions that Mr. Blevins personally appear for email court hearings. That you abide by any judgment entered in the case and surrender to. Sure. I need to turn the volume on your device down.
Sorry.
Okay, sorry. So you must, again, abide by the judgment entered in the court and surrender to serve any sentence imposed. You must not leave the state of Michigan without permission of the court. You must not commit any crime while released. You must immediately notify the court in writing of any change of address or telephone number. You must make reports to Mr. Coast in Little County Court, Circuit Court Services as specified by him. You must not use alcohol, marijuana, or any illegal controlled substances.
Thank you, Your Honor.
And I'm going to put you in a breakout session with Mr. Stevenson from the probation department so he can collect your information and give you instructions about reporting to them for pre-sentence investigation interview.
Okay. Thank you, Your Honor.
Okay, give me just 1 second here to get that breakout room set up. Ms. Underwood, are you ready to proceed with Mr. Colwell?
Your Honor, I believe Ms. McClure is on that case. Is she?
Ms. McClure, are you handling Mr. Colwell?
Yes, I am.
Didi, can I step outside just for a second and call? Can I step outside just for a second and call you?
Yeah.
Thanks.
Telling judges. Could we have William Raymond in a room for the judge, please? All right, thank you. Bye. Okay. Judge says he doesn't have to.
Okay, this is file 24-21989-FH, People versus Joseph Michael Colwell. We're here today for a pretrial conference in the case. We are proceeding today partially in person, partially by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. McClure?
BB McClure on behalf of the people.
Rhonda Underwood on behalf of Mr. Caldwell, Your Honor.
All right, and where are we with Mr. Caldwell's case today?
Your Honor, the offer on this is Mr. Caldwell will plead guilty to count one, and with one supplement, the other supplements, excuse me, being dismissed in this matter, Your Honor.
So, and I wasn't sure, Judge, if you needed an amended reflecting that it's a habitual second offense instead of a habitual fourth offense.
I will need that. Yeah, I think we can go forward, but
okay,
just make sure that gets caught up with the.
Okay.
File. Okay. So I'm sorry, Ms. Underwood, you said he's pleading to count one with the second habitual notice rather than the fourth. Is that accurate?
I count one with one habitual, Your Honor.
Okay. And Ms. McClure, is that a complete and accurate statement of the agreement?
Sorry, it is, Judge.
Okay. Mr. Colwell, will you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, that's murder.
I need you to say that you do or you don't.
I do.
Okay. You can put your hand down if you want. You are Joseph Michael Colwell?
Yes, sir.
You've heard the statement of your attorney and the prosecuting attorney, Mr. Colwell, is it your intention to plead guilty today to count one, assault of a prison employee?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
Do you understand that with the habitual offender notice, the maximum possible penalty for that offense will be up to 10 years in prison and or a $5,000 fine?
Yes.
Is that with just one?
Is it? I doubled that. Is that just 1.5?
It'd be 1.5.
Sorry. I misspoke, Mr. Colwell. The maximum possible penalty would be 7.5 years. Do you understand that?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice she's given you?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. McClure?
That's correct.
Ms. Underwood?
It is, Your Honor.
Is that also your understanding, Mr. Colwell?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to presume innocence. until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Mr. Colwell, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, sir.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea will be by application for leave to appeal and not by right?
Yes, sir.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about March 9, 2024 in Madison Township, Lenawee County, Michigan, that you did commit the offense of assault of a prison employee?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you're giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Oh, sir.
Has your attorney promised you any particular sentence or estimated what your sentence would be?
Yes.
What has she told you about your sentence?
She said it'd be 7 years and a half.
Okay, she told you that's what the maximum possible sentence would
Oh,
be. Is that right?
no. The next date is, I'm not sure. I forgot.
Okay, so do you understand, Mr. Colwell, that the maximum possible sentence that you can get for this, the most time that you can serve for this is 7.5 years?
Yes, sir.
Do you understand that it's my responsibility as the judge to set whatever the minimum sentence is going to be?
Yes, sir.
And do you understand that there's no agreements or anything about what I might do with respect to that minimum sentence?
Yes, sir.
Okay. Is it your own choice to plead guilty today?
Yes, sir.
Ms. Underwood, do you want to cover the factual basis?
Yes, Your Honor. Thank you. Mr. Caldwell.
Yes.
I take you back to March 9th, 2024. Were you
Yes.
incarcerated at the Gus Harrison facility in Madison Township, Lenawee County, state of Michigan?
Yes. Yes, ma'am.
And you were lawfully incarcerated there, correct?
Yes.
And when you were incarcerated there on that date, did you come into contact with Stephen Sager, an employee of Gus Harrison?
Yes, sir. Yes, ma'am.
And he was conducting his duties as a correction officer there, correct?
Yes, sir.
And at that time, did you spit on Mr. Officer Sager?
Yes, ma'am.
And you had no permission to spit on him, correct?
Yes, ma'am.
And you know that spitting is an assault, correct?
Yes.
I believe the facts are established, Your Honor.
Ms. McClure?
Oh, I'm sorry. And Mr. Colwell, you were previously convicted of assault of a prison employee in Jackson County on or about March 7th, 2023, correct?
Yes.
And there's the supplement, Your Honor.
Okay, Ms. McClure?
I'm satisfied, Judge.
Has the court complied with MCR 6.302 B, C, and D, Ms. McClure?
It has.
Ms. Underwood?
It has, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Colwell has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for December 19th at 8:15 a.m. Mr. Colwell, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
All right. Yes, Your Honor.
Right. So we're all set. You can let the officers with you know that you're done with court.
All right.
And I did forward a plea form. Maybe we can just make it part of the file. I understand the plea's already been entered, but that hadn't been received back yet, signed.
Okay. I did forget to ask, Mr. Colwell, you have a right to be present in person for the sentencing hearing, or we can do it by Zoom if you want to waive your right to be present in person.
I don't
You
see
have
we
Zoom.
have prints for him.
I'm sorry?
I don't see we have prints for him in the system.
Okay, so we need fingerprints, so we're gonna have to do that in person. So Ms. McClure.
It's gonna be I'm almost all the way up upstate. I'm at Gus Harrison Correctional, St. Louis, Michigan. That's kind of long distance.
All right, if they can arrange to get your fingerprints before that date and get the information in the system, then we can do it by Zoom. But otherwise, we're gonna have to do it in person.
All right.
Okay, thank you, Mr. Colwell.
Yeah.
Mr. Murphy, do you need a breakout session with Mr. Raymond?
No, Your Honor, I'm ready to proceed.
These are files 24-21807-FH, 24-21808-FH, and 24-21890-FH, People versus William Michael Raymond. We are here today for pretrial conferences in each of those cases. There is also a pending contempt of court for violating bond conditions in each of those files. Proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayonet for the people.
Matthew Murphy, appearing on behalf of Mr. Raymond.
All right, and Mr. Murphy, where do we stand with Mr. Raymond's cases today?
Your Honor, I was going to ask if we could adjourn these matters. He does have two new felonies pending down in district court. They have a probable cause tomorrow. Our intention is to have those cases come upstairs for an arraignment soon. I am going to have Mr. Raymond re-screened, have a fresh screening done for recovery court, see if he qualifies for that, and then update Mr. Bayonet on that and see where we stand with an offer from the people. With everything. So again, if the people would have no objection, I'd ask for an adjournment. With him, his new files being up, obviously my intention is to get those up as soon as possible. We could probably set these for the same date that arraignment on those would be, which would be about 2 or 3 weeks from now, I'm guessing. I'm not 100% sure. But whatever fits the court schedule best, we would defer to the court.
Okay, I'm sorry, so he's where is he in the district court process right now?
There's a probable cause conference tomorrow. If we waive his exam, then his arraignment in circuit court would be, I believe, November 20th. I put in to have him screened for recovery court. Hopefully that will happen next week. So maybe if we were to do this November 20th, if there'll be no objection to that, maybe we could have something worked out by then, with an understanding if he qualifies for recovery court.
Okay, so if he's arraigned on the 20th, I'm not here that day, so Judge Anzalone's going to be doing the arraignment. I can set it for the week after that on November 27th and just let Judge Anzalone know at the arraignment to set it for the next week, and we can have them all together on the 27th.
Yeah, could we do that? I could just waive the arraignment then and just have the pretrial on the new files and just do that for the 27th then, if that would work.
Yeah, we can do that too.
Thank you, Your Honor.
Okay, so, Mr. Murphy, would you do stipping orders for these 3 files then?
Yes, Your Honor, I'll have those prepared. Can we sign your name to these, Mr. Baronetto?
You can, yes, thank you.
All right, anything else we need to address with these cases?
Nothing from the defense, Your Honor, thank you.
Nothing from the people, Your Honor.
All right, Mr. Raymond, you're all set. You can let them know you're done with court.
All right, thank you, Your Honor.
Thank you.
All right, so McCollum.
Your Honor, that's all that I had down for my schedule. I was going to go ahead and log off now. If I was wrong, I guess I'll reappear though. If you need me. So.
Okay, thank you, Mr. Murphy.
Everyone have a good day. Thank you.
All right, this file 24-21958-FH People versus Skylar Austin McCollum Rosa. We're here today for a pretrial conference in this case. We are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Mr. Baronetto.
Alex Baronetto for the people.
Ron Underwood for Mr. McCullough Rosa, Your Honor.
All right, and this is set for pretrial conference today. Was set for 8:15 a.m. this morning. It's now 10:38. Mr. McCollum Rosa is not present in the courtroom, nor has he logged into the Zoom session at any point this morning. Ms. Underwood, anything you want to say with respect to Mr. McCollum Rosa?
Your Honor, Mr. McCullough Rosa was in court with me downstairs last week, bright-eyed, on time. I don't know where he is today, Your Honor, and the number I have is disconnected, so I can't track him down right now. But I'm willing to bet this is a mistake on his part, and a serious one. I would ask the court, if the court is going to issue a bench warrant, to give a grace period, Your Honor. But in the alternative, if the court would consider a show cause for 2 weeks from now, and I can reach Mr. McCullough Rosa by a slower method than telephone, Your Honor.
Okay, Mr. Baronetto, any input?
Yes, Your Honor. I'd ask that the court issue a bench warrant immediately. On top of the domestic violence that is charged in this case, the defendant has an aggravated assault and a domestic violence pending against him in district court with the same victim. There is also another case with the same victim that has to do with unlawful posting of messages. The defendant was posting some derogatory things. I'll just leave it at that without getting too much into the facts. But these all have to do with the same victim, and much of this contact has already been after a no contact order was issued in June of this year. Skylar has shown he's not going to abide by orders of this court. The fact that he is now not appearing today, I think warrants an immediate bench warrant, and I would ask that the court issue that at this time.
Your Honor, I would just state that there have been no complaints since Mr. McCullough Rosa got out of jail that he is in any way violating the no contact. I don't know where he is today, but I would suspect that is another issue altogether. I would ask the court to consider a 48-hour grace period on the bench warrant, Your Honor. Thank you.
All right, so the issue before the court right now is a failure to appear. I don't have any information about other bond violations since he was released, and so I'm only treating this as the failure to appear. I don't see any prior failures to appear in the file. And so he is entitled to the 48-hour grace period. So I will grant him that. If we have not heard from Mr. McCollum Rosa in 48 hours, the court will revoke and forfeit bond to a bench warrant and set bond in the $25,000.
Thank you, Your Honor.
All right, thank you.
Does the court have anything else? I believe there are some pickups.
We took care of our pickup. I think we are all set.
You're all set?
Yes.
Thank you very much.
Okay, thank you. And Mr. Malero, we're calling for Mr. Madrid right now.
Okay.
Thank you. Bye.
Okay, Mr. Malero, do you need to speak to Mr. Madrid?
Yeah, probably just for a few minutes, Judge.
Okay, 1 second. So Ms. Holly, we still had to sentence him on one violation of probation and then he has a second one, is that right?
So I didn't add, he's got a new file, a 24 file, sentencing's in
Yeah.
December. So I think you wanted to put all this together, but the violation is just, he already pled guilty. So
Right,
we
okay.
did what happened was he didn't show up to sentencing. So that's why there was a report already done and I just updated it. Because the way the guidelines are and everything, I didn't even add a new violation on the new crime. I addressed it, but that was before he pled. It's very confusing.
Yeah, it is. So we just had he was just supposed to be sentenced and we never got him sentenced on that.
Right,
violation.
right.
Okay.
So you can either do it now or later. It doesn't matter to me. I don't know what Mr. Malaro wants to do.
And then he's got a bunch of contempts.
Right, right.
Okay, this is file 22-20968-FH, 22-20969-FH, and 22-20972-FH, all people versus Michael Anthony Madrid. We are here today for hearing on a violation of probation and I believe 3 contempts in each file. We are proceeding today by video conference. Mr. Malero, do you want to place your appearance on the record?
Salvatore Malero on behalf of Michael Madrid.
Okay. And so in review of this file, I'm not sure I understood it correctly last week when he pled to the new file. But the violation of probation in these 3 files, he had already pled guilty to. And we had a sentencing date set, and then Mr. Madrid did not appear at that sentencing, so I think there are several contempts related to that. Do I recall correctly, Mr. Malero, that does the plea on the new file, the 24 file, is there going to be a prison sentence for that?
Yes, Judge, there was an agreed sentence of 48 on the charge and then 2 + 2 for the gun. So
Okay.
it's whatever that is, whatever math says that is. 4 + 6 years, so it's gonna be 60 months total.
Okay, so I think what we can do, since he's already pled guilty to the only violation of probation in this file, is set the sentencing on that for the same date as our sentencing date in the new case. And then it would make sense to me, I think it would be in the interest of justice just to dismiss any of the pending contempts because none of those are going to impact his situation regardless of what happens.
Yeah, Judge, may I speak to all that?
Go ahead.
So, I mean, we appreciate the fact that you would, in the interest of justice, dismiss that. And the charge for which his prison sentence is pending is scheduled for December 13th. The PSI has been done. I've spoken to Ms. Holly and Mr. McCready on that. There's probably going to be a little bit of an adjustment, but there is a sentence agreement. Mr. Madrid has significant health problems and it's deteriorating. And so the sentence is actually scheduled for December 13th, but we would request of the court to consider moving it up even to like this Friday if the court was willing.
I can, so Ms. Holly, you've got everything completed, so we're ready to go.
I did do it. I'm gonna have to change it because of the way the guidelines came out. I'm gonna have to change my recommendation. I can do that tomorrow. I'll send it to you guys.
Okay.
I think I recommended 5 years and it's actually a 7-year guideline. So I have to change it to that. My recommendation.
Yeah, I think we can do that. We can do that this Friday.
Okay.
So Friday then at 8:15, we'll set everything for sentencing.
I'll just adjust, I'll adjust the credit when I make those changes.
Okay, great.
All right, thank you, Judge, and I'll let Mr. McCready know.
Okay, thank you. Appreciate that. Anything else we need to address for Mr. Madrid today?
I do not believe so, Your Honor.
Okay. Thank you then. Mr. Madrid, you can let the officer with you know that you're done with court.
Thank you, sir.
Thank you, Judge.
Okay, thank you.
Mr. Moore.
I think that's it, right, Your Honor? I took over for Ms. McClure halfway through. I just wanted to make sure.
Yeah, that's everything I have.
Okay, have a good day.
Take care, Judge.
Thank you. See you later.
Yep.
So his